Carol Magnasco is a qualified accountant who was employed by Mansion Gibraltar in 2010. He became the Chief Financial Officer in 2012 and the Chief Executive Officer in 2017. He also served as the sole director of several Mansion companies. The second defendant in the case is KM Accountants, a company that Mr. Magnasco controlled. Due to concerns over certain transactions involving one of the Mansion Group companies, an investigation into Mr. Magnasco's conduct began in September 2021. During that period, he was suspended. However, by December 2021, before the investigation concluded, Mr. Magnasco resigned as CEO and from his directorships. The Claimants, Mansion Gibraltar and Onizac Limited, filed their legal case in September 2022, accusing Carol Magnasco of breaching various fiduciary, non-fiduciary and contractual duties during his time as CEO and director. The claimants are seeking compensation totalling £2.3 million and €2.9 million, and they also want Mr. Magnasco to account for any benefits he or his related parties may have gained from his roles in the companies. The claimants later added new accusations of unethical behaviour by the defendants related to the original breaches in the lawsuit. The defendant sought to amend his defence and counterclaim and alleged that Mansion Group is a criminal organisation engaged in unlawful and immoral conduct. Mr. Magnasco sought to claim loss and damages of £2.1 million and general damages for loss of reputation and mental distress and anxiety to himself and his wife. He also alleged that he resigned because of what he called the hostile and biased investigation that was being conducted against him. However, the Supreme Court dismissed Mr. Magnasco's application to amend. Moving on to the Without Prejudice letter, the letter sent by Christopher Finch of Verralls to ISOLAS said the actions of ISOLAS junior lawyers had disrupted potential settlement negotiations. He expressed concern about the potential negative impact on Gibraltar if the case went public, suggesting that pursuing the case could harm both parties and the jurisdiction. He said he also felt obliged to inform the Chief Minister. He urged a settlement to avoid mutual annihilation and warned of severe consequences if the case continued. In his response, ISOLA's senior partner, Peter Isola, denied the allegations that were made in the letter. He argued that the claims were baseless and accused Mr. Finch of misusing the Without Prejudice veil of privilege for what was tantamount to blackmail. He said further correspondence would not be conducted on a without prejudice basis due to the serious nature of the threats. Verralls denied the accusations, arguing their letter was a legitimate attempt to settle a potentially damaging and expensive dispute. So what is the Without Prejudice rule? Well, the rule exists to encourage parties to settle disputes out of court without fear that their statements will later be used against them in court. However, the rule is not absolute, and should the court determine that it was being used to hide serious misconduct or improper behaviour, then the court may allow it to be used as evidence. In a detailed judgment, the Supreme Court granted the claimant's application to include the purported Without Prejudice correspondence as evidence by invoking the rarely used Unambiguous Impropriety rule, although the Chief Justice said this evidence is not relevant to determine the amended application. The defendant's application to amend the defence and counterclaim was dismissed. The defendant's application for specific disclosure was also dismissed. However, the court will hear further submissions regarding costs from the parties. The full judgment is available on the court's website. GBC understands relevant decisions of the Chief Justice are already the subject of notices of appeal, and this latest decision will be added to the list.